Ladies and gentlemen, esteemed guests, faculty, and judges, welcome to the final round of this moot court competition. I firstly extend our warmest greetings to everyone in attendance. To start off this event, I would like to invite Vice President of Academics, Professor Dr. Altaf Makati, and we request him to deliver the welcome address to set the tone for this final round.
Bismillahirrahmanirrahim. Ladies and gentlemen, SZABMOOT is our regular activity, which is basically a mooting competition, well organized by our law department. Today is the final round of this activity. On this happy occasion today, I, as a Vice President Academics, very warmly welcome to all our esteemed guests, honorable judges, faculty members, students, and all other participants. Before we proceed, let me express my deepest gratitude to our distinguished panel of judges who have graciously accepted the responsibility of evaluating the final round. We are honored to have with us today Dr. Fiaz Hussain Shah Sahab, the Prosecutor General of Sindh, Advocate Salim Thapdewala, a senior advocate of the Supreme Court of Pakistan, and Advocate Asma Jawaid, an esteemed member of the Advisory Committee of the Law Department. An advocate of the Sindh High Court, he has still not turned out, Mr. Haider Wahid Saab. Okay, thank you. So your presence adds immeasurable value to this event, and we are grateful for your time and expertise. I am extremely thankful to Ms. Rafia Jafar and her team organizing this event. Let me mention very briefly about SZABIST University. It was established in 1995 under the act approved by the Sindh Assembly. It is founded by Mohtarma Benazir Bhutto Saiba. It was started with just two programs, MBA and MS Software Engineering. Along with the passage of time, its growth has remained exponential. Today we have 6 campuses. Karachi campus is the mother campus. We have campuses in Islamabad, Hyderabad, Ladkana, Garo, and also in Dubai. In 2002, we started our law program in collaboration with the University of London. As the oldest recognized teaching center, our commitment goes beyond the classroom. We strive to not only impart the legal knowledge, but also to mold our students into proficient and ethical legal professionals. We have been offering a 3-year University of London LLB program, and I am very pleased to mention that 90% of our students pass their exams in their first attempt. The SZABMOOT is an annual tradition of our law department designed to teach students the intricate art of legal research, promote creative thinking about legal arguments, and refine their advocacy skills. This competition is a vital learning experience for our law students, who are encouraged to participate wholeheartedly. The past 2 days have witnessed 12 teams engaging in heated legal arguments and facing rigorous questions from our esteemed judges. I hope the final round today will be exciting and thrilling, and it is expected to be intellectually stimulating to determine the ultimate winner. Thank you very much. The best of luck for the finalists.
Thank you, Dr. Makati. Now, I am honored to introduce the eminent individuals who will be presiding over today's proceedings, and I request them to take their seats on the panel as their names are announced. Please join me in welcoming our esteemed judges, Ms. Asma Jawaid, Advocate Sindh High Court, and a member of the Advisory Committee for our Law Department. Advocate Salim Thapdewala, a senior advocate of the Supreme Court. And lastly, Dr. Fiaz Shah, the Prosecutor General of Sindh. Now, without further ado, let us commence with the much anticipated final round of this moot court competition. Thank you.
All right. Court is now in session. The matter before the Lebanon Court of Appeal today is FPX PLC versus Equential Limited. The appellants may begin with their submissions. Both teams are requested to be on their podium. Miss.
Good evening, Your Lordship, Your Ladyship. If it so pleases the court, may I begin my submission? Much obliged. My name is Hamna Shayar, and I will be speaking in favor of FPX PLC. I will be speaking for a total of 13 minutes, in which I will be addressing the first issue to argue that the terms of service agreement satisfy the reasonability requirement under Section 11 of the Unfair Contract Terms Act, 1971. With my co-counsel, Shamir Ali, speaking for 13 minutes as well, with 4 minutes of rebuttals. With your permission, may I begin with a summary of the case facts? Much obliged. Equential PLC, a seed company established in 2020, faced challenges meeting high demands due to limited storage facilities. The contracted FVX PLC for secure and climate control warehouse space, but encountered payment delays and warehouse inaccessibility due to FVX protest. Equventure sued FVX 5 months later to recover losses incurred under the contract. I would invite the judges to refer to page number 9, paragraph 1 in the memorial. Unfair Contract Terms Act 1971 is a statute that imposes limits on to the extent to which liability for a breach of contract, negligence, or other breaches of duty can be avoided. With the permission of the bench, may I read my relevant section? Much obliged. The reasonable test is set under Section 11 of the ACTA 1977, which states that the term shall have been a fair and a reasonable one to be included, having regard to the circumstances which were or ought reasonably to have been known to or in the contemplation of the parties when the contract was made. Where the parties, FVX and Equventure, aware of these circumstances, and Equventure Ltd signed the contract with free care, with knowing that the section was the Section 11 stated. The factors that considered out in Schedule 2 of the Section 11 ACTA A, the strength of the bargaining positions of the parties relevate to each other, taking into account, among other things, alternative means by which the customer requirement could have been met. Your Lordship, Your Ladyship, the bargaining position of Equventure Ltd was much higher than FVX PLC. Equventure Ltd had a market share of 30%, while FVX PLC had a market share of 15%. We were far more worse than a position compared to Equventure. Hence, the term in the contracts are reasonable according to the Section 11, Schedule 2, Part A. B. whether the customer received an endorsement to agree to the term or in accepting it had an opportunity of entering into a similar contract with the other person but without having a similar term. Similarly, nothing like this was stated in the case facts. Schedule 2 also has Part C, D, and E, which are not applicable in this case. Your Lordship, Your Ladyship, as mentioned in the Warehouse Service Agreement, FVX PLC and Adventure PLC entered into the contract on 15th of January 2022. And as stated, it shall expire 6 months later from the effective date or upon the failure of consideration. Either party may terminate this agreement with written notice if the other party breaches any material term or condition. FVX did not breach any term as the protests that took place were not in their control. The backlash was so intense that the roads to the warehouses were obstructed by the protesters. Your Lordship, Your Ladyship, XVS company had no idea that the protests would lead to such extent that would force the government to take the legal action to seal their warehouses for inspection temporarily. In this case of Paradigm versus Jane, it was established to the circumstances beyond their control. It is mentioned in the memorial on page number 9, paragraph number 2. With the permission of the Honorable Bench, my researcher, Ms. Laiba Urshad, would like to give them the case file containing the case facts of the case laws we're using. Your Lordship, Your Ladyship, according to Clause 4 in the Warehouse Service Agreement, it was stated that either party shall be excused from their performance under this agreement in the event of any unforeseeable circumstances beyond their control, which includes but is not limited to the acts of God, war, terrorism, and natural disasters, making performance commercially impractical. This list is non-exhaustive to include any unforeseen circumstances. The affected party shall promptly notify to other party of such circumstances. The intensity of the protest was so high and the protest escalated so quickly that FPX did not have the chance to notify Adventure. Regardless of the fact, even if they had or even if they had not, it clearly states in clause number 5 that party A shall not be responsible of any damages or losses faced by any factor beyond their reasonable control, and take reasonable measures to resume performance as soon as possible. This was seen in the case of Davis Contractors versus Fairham, 1956. It is mentioned in the memorial on page 9, paragraph number 3, where the House of Lords held that the fact that unforeseen events made a contract more onerous than was anticipated. This clause shows that FVX was not in breach under Section 11, as it was made clear in the terms that any unforeseeable event beyond the party's control would be disregarded. Thus, the contract should continue according to the agreement. The legal definition of the unforeseeable event is the occurrence of events or circumstances which are beyond the control of the affected party. This allows for both parties to reduce their liability. This clause was agreed upon by Adventure in the Warehouse Agreements Act, in the Warehouse Service Agreement. Hence, the contract into the account. The contract has not been breached. Henceforth, I urge the Honorable Court to take the above factors into account. Yes.
Can you hear me now?
Yes.
Okay, there was a clear policy of the government that the carbon footprint has to be reduced to 0.
Yes.
Now, who was responsible for that, the unavailability of that certificate, and why was there not enough effort made by this company, FVX, to reduce the carbon footprint to 0 and obtain the certificate for that purpose?
Thank you for the question, Your Lordship, Your Ladyship. I would like to address that by saying that the protests that firstly took place were in 2020. It was 2 years later after this contract was made between FVX and PLC. There were no protests between the 2 years of time being. Moreover on that, Agriculture Ltd knew that the warehouses are being run on generators, especially for the feature that they were very intrigued by, which was the environment control feature. The warehouses give that facility to the Agriculture Ltd by using the generators.
Counsel, this does not exactly answer my question. You already know it.
The efforts were made by the FVX PLC. We revamped the CR policy as well within the 2 years of time. That's why the protest didn't happen in between the 2 years of time being. Does that satisfy your question, Your Lordship?
My question was, why was there no effort made to reduce the carbon footprint?
The effort was made.
They have not made any effort, and there was no such mention in the memorandum or anywhere.
As if you can see in the case facts, it clearly states, line number 3, recently the company revamped their corporate social responsibility, CR's policy, to reduce their on-site gas compensation.
And aimed to achieve zero carbon
Yes.
certificate
This
status.
happened when the first protest occurred in 2020.
Okay. But it was not reduced, and that's why the second protest took place.
In the 2 years of time being, there were no protests faced by FVX. Hence, that is what made the event
It
more
does not say
enforceable.
that there were no protests. It says that the protest escalated significantly. It does not mean that there were no protest.
The warehouses which were used by the Adventure Ltd clearly mentioned all the facilities that they were using. It also clearly mentioned in the case fact that the warehouses were using generators, and the generators were the reason why the carbon dioxide was released. Hence, due to this revamping of the whole company, efforts were made, and they still aim to achieve the zero carbon aim policy. In the 2 years of time being, things had gotten better for them. Things did got better for them.
Okay, thank you.
Both companies introduced this clause: if any disruption occurs in this contract, they shall not be liable for it. FE has a 15% market share, while Adventure has a 30% market share. Your Lordship, Your Ladyship, the company Adventure Ltd has a known big reputation and would probably know about the protest FE had already faced. Your Lordship, Your Ladyship, protests are a part of public knowledge.
Please refer the clause of the contract whenever you
It's the clause number 4.
write, whatever you want, whatever you want. So you refer. If you see this indemnity clause, you would have to refer the clause.
It's the force majeure clause. Yeah. In the event of unforeseeable circumstances beyond their control, which includes but is not limited to the acts of God and war and terrorism, national disaster, making performance commercially impracticable. Your Lordship, Your Ladyship.
Your precise argument is in terms of clause 4. So you have a good defense.
Yeah. Your Lordship, Your Ladyship, protests are a part of public knowledge. Moreover, Your Lordship, Your Ladyship, the first occurrence, as I said, happened in 2020, and it was after 2 years when the agreement was made with Adventure Ltd. That is 2 years later when both companies came into the contract. Your Lordship, Your Ladyship, after the first protest in 2020, measures were taken by FVX. They knew that FVX uses generators for their warehouses, especially for their environment control systems. Moreover, the protest wasn't even the real reason why the warehouses were sealed. It was the government action which caused the warehouses to be sealed temporarily. The government, as the case laws of task photos versus municipal finance services, it is mentioned in the memorial on page 10, paragraph number 2. Where the contract for the sale of land became impossible to perform when the government compulsorily purchased the land before the closing date. Hence, the government action was not in control of FVX the involvement of a third party in this case, the government being the third party, adds another layer to the unforeseeable events. I would like the honorable bench to take into consideration the fact that FVX had no idea that the roads being obstructed would lead to the government closing down the warehouses temporarily for inspection. Either FVX was informed by the government that such action would take in the future, neither a warning was given by the government in any of the cases. The contract also incorporated an indemnity clause 5, meaning an acknowledgement and a promise by one party to another to cover the potential liability suffered by the other. Even though FVX agreed to the indemnity clause, it was not held liable for any losses or damages resulting from the factors beyond its reasonable control. This clause clarifies that FVX will not be held liable for any losses or damages beyond its control. The protest that led to the roads being obstructed and the authorities sealing the warehouses temporarily only for inspection service, your lordship, your ladyship, went beyond FVX control. Therefore, this clause was not being breached. In the case of Ocean Tanker Co. Ltd. versus Valor Line International Transport, it is mentioned in the memorial on page 10, paragraph number 3. An indemnity clause excluding liability for a party's negligence only applies to ordinary negligence and not gross negligence or willful misconduct. The legal definition of negligence states that negligence is when the defendant has breached a legal duty of care which was owed, leading to a claimant being harmed or suffering a loss. No ordinary negligence occurred on the behalf of FVX. Hence, as long as it did not contribute to the events through negligence or misconduct, the exclusion within the indemnity clause may protect them from the liability for adventure's losses.
Counsel, you mentioned the word Can you hear me now?
Yeah.
You're mentioning the word may. So it feels that you are still not sure for yourself if it will or will not. May has all sides of possibilities. You're still not sure whether they'll not be responsible for any of their non-compliance to the CSR policies.
Thank you for the question, Your Ladyship. I am very sure about this fact that the indemnity clause is that FVX Ltd is not under the indemnity clause and is not liable for it, and it should not pay for the adventure's losses in any kind, as no clause has been breached by FVX in the first place.
Thank you. Thank you. Next.
If there are no further questions, with the permission of the honorable bench, I would like to call upon my co-counsel to address the issue of frustration.
If it so pleases the court, please may I begin my submissions? Thank you. My name is Shamir Ali, and I will address the second and third issues put forward in this appeal. The second issue is whether or not the contract was frustrated due to the protests in Ambikar. The primary legal authority on the frustration of contracts is the Law Reform Frustrated Contracts Act 1943. This act, however, does not provide a clear list of situations under which a contract would be rendered frustrated. Therefore, relying on precedents set on this issue, I will attempt to establish that the contract between AgVenture and FVX was not frustrated and persuade the Honorable Bench to overturn the previous decision. Frustration of a contract occurs when unforeseen circumstances that are beyond both parties' control prevent performance, as seen in the case of Taylor versus Caldwell, 1863. This is mentioned in the memorial on page 11, paragraph number 2. It states that if something central to the performance of the contract no longer exists, then the courts will find that the parties' obligations have come to an end. It is seen in this case that there were protests against FVX because of their high carbon footprint, and the protests were so severe that they led to the authorities having to temporarily shut down the warehouses for inspection. As the warehouses were shut down, AgVenture could not access their goods. This does not by any means establish that the contract was frustrated. Firstly, the protest was only a temporary problem and the warehouse were to be functional shortly after inspection. Therefore, it cannot be said that the contract could not proceed. This was seen in the case of National Carriers versus Panalpina, 1981. This is mentioned in the memorial on page 11, paragraph number 3. It was ruled that as long as the contract can continue, a short pause in performance is not enough to deem the contract frustrated. Apart from this, accessing the goods was not the sole purpose of acquiring FVX's warehouses. They were also rented to provide safety and a suitable and state-of-the-art environment for AgVenture's seeds. Due to these facts and other purposes of the contract being met, this contract cannot be said to be frustrated, as it was seen in the case of Hearn-based Steamboat Co. versus Hutton 1903. This is mentioned in the memorial on page 11, paragraph number 3. It stated that as long as the purpose of the agreement is partially completed, the contract is valid and enforceable.
You tell us what the contract had been performed between parties.
Thank you for your question, Your Lordship. As I mentioned before, accessing the goods was not the sole purpose of acquiring FVX's warehouses. They were also rented to provide safety and a suitable and state-of-the-art environment for AgVenture's seeds. So I don't understand your question. Your Lordship.
What the performance ought to be done initially by party A to the party B. So if you want to keep yielding seats there, so what you have done and what they have done.
Thank you for your question, Your Lordship. FVX had agreed to rent their warehouses to AgVenture for the...
They have agreed. Then what action has been taken by you? Have you made some advance payments for the premises you want to?
AgVenture had paid for the 50% payment that they were supposed to pay.
For part performance.
Yes.
Okay.
Yes.
Now here you start, son.
Okay, thank you. If there are no further questions, with the permission of the Honorable Bench, I would now like to address the third issue. The third issue in question is whether or not Section 1, Subsection 2 of the Law Reforms Act 1943 is applicable. Your Lordships and Ladyship, while I have no doubt established that the contract has not been frustrated, it is necessary to briefly mention the scope of Section 1, Subsection 2 of the Law Reform Frustrated Contracts Act 1943. Section 1, Subsection 2 states that when a contract is frustrated, any amount paid to a party during the contract shall be paid back to the original party. However, Section 1, Subsection 2 only applies to completely frustrated contracts, which is not the case here, as I established in my previous point. The facts of this case do not justify AgVenture's claim of this contract being frustrated, as observed by the list of relevant authorities mentioned above. As a result, Section 1, Subsection 2 does not apply to this case, and we urge the Honourable Court to reconsider the previous decision and grant the appeal to FVX PLC.
Counsel, can I ask you a question? What was the main purpose of this contract between party A and B?
Thank you for your question, Your Lordship. As mentioned in the case facts, the main purpose for this contract was because AgVenture had faced high demand for their HYV seeds and there was a lack of storage facilities. Therefore, they contracted with FVX PLC due to their reputation for state-of-the-art and environmentally controlled warehouses, which were suitable for AgVenture's product.
The purpose of storing the seeds in that storage house or the warehouse, what was needed by this company, AgVenture?
AgVenture needed the environmentally controlled warehouses
and they also
safety.
needed access to the product that they were storing in the warehouse.
Yes.
So if access was denied to them due to the government sealing the premises, how is it that the contract was not frustrated?
Thank you for your question, Your Ladyship. As I mentioned before, in the case of Hearn-based Steamboat Co. versus Hutton, as long as the purpose of the contract is partially completed, a contract is said to be valid and enforceable.
That's true, the contract is valid. But the point is whether the circumstances was beyond control of this FVX or not. How do you
Justify that?
Justify it?
Your Lordship, as my co-counsel mentioned before, the protests first took place in 2020, and after that, the company FVX had revamped their corporate social responsibility.
We understand that. The point is, when the property was, the warehouse was provided, was available, you have inspected, you are satisfied with that, and you, with your consent, you entered into contract. The point is, you were not allowed to keep storage of the seeds. That's the point.
After the protests took place,
After the protest.
AgVenture...
But was this on the part of FVX or was beyond his control? How do you see about it?
Your Lordship, the protests were beyond FVX's control. After the protests took place, Agventure sought alternate storage
Yes,
facility.
exactly. So
Yes.
is it not beyond the control of FEX and it is not the frustrated terms of the contract?
Thank you for your question, Your Lordship. It is beyond the control of FVX, but as the precedent set by Hearn-based Steamboat Co. versus Hutton states, that the partial uh, agreement was completed. Therefore, we are relying on the clause 5 of the Warehouse Services Agreement Act, which states that party A shall not be liable for any losses or damages resulting from factors beyond its reasonable control. If there are no further questions, I would like to conclude my submissions.
The, the, the agreement was executed in 15 January, on 15 January, okay? And the partial payment was required to be made on or before 27 February 2002.
Yes.
Prior to demonstration of the public against the warehouses, was there any lot stored by the tenant in the premises or not?
Sorry, can you repeat your question?
During the period from 15 January to 27 February, the party FPG stored any lot of its item seeds in your warehouse or not?
Storage.
Storage was started or not?
Thank you for your question, Your Lordship. It is not mentioned in the case facts when they stored the goods, but it is mentioned that they contracted on January.
No, my question is, so far the part performance on the point of view of payment of rent and deposits is concerned as a different thing. Whether practically they stored their seeds in your warehouses or not prior to demonstration. If prior to demonstration he has not stored anything in your warehouse, it means practically the contract is not implemented except the point of payment of rent or the 50% deposit. So my question is, prior to the demonstration, was there any storage in your warehouse or not?
No, Your Lordship.
No. It means contract was only remain on paper, practically it didn't took place. Isn't it?
Yes.
Sir, will you able to return the advances whatever you received?
Can you repeat your question?
Well, how do you say if you are prepared for your case? So the payments received by you against your property, so in your pocket. So in case the respondents give his consent, so will you able to waive the right of damages? Will you able to return the payment whatever you have received in advance?
Thank you for your question, Your Lordship. As I mentioned in the Warehouse Services Agreement, the clause 5 states that party A shall not be liable for any damages or reimbursement for factors beyond their reasonable control. As the protests were beyond their reasonable control,
Where is the word reimbursement or return has been labeled, as you referred in clause 5?
apologies, Your Lordship.
Go and read clause 5.
Party A agrees to indemnify and hold harmless Party B from any claims, losses, or damages arising out of the warehouse's gross negligence.
So there is no word of reimbursement.
My mistake, Your Lordship. I meant to say losses or damages.
Losses, if the respondent party who has succeeded his case in the court below, so if he waives his right of losses and damages, if you see this claims, losses and damages, if he waives claims, losses and damages, will you able to return the advances, whatever you received from him?
Your Lordship,
What do you say about it?
the initial payment.
This is. I'm asking you another situation. One is the one party has won. You have come in appeal. So another situation, your appeal is allowed and they loses. But this is the third situation where we can go for a compromise, for a consent order. So in this situation, you have to agree on terms. So if the parties suggest that, okay, sir, I forgive my losses, my damages, but let my advance money, 50%, whatever I have given to you. So what do you say about it?
Your Lordship, the advanced payment that we have received cannot be retrieved by Agventure PLC.
You're unwilling to return any amount that you
Yes.
have received so far?
Yes.
Okay.
So then another two situations comes. Either it's your malafide, or it's the cost you have bear for the at the advice of adventures.
Thank you for your question, Your Lordship. The initial payment, the 50% of the payment that was received by FVX, was incurred towards the performance of the contract.
This is the point you ought to argue.
It was incurred towards the performance of the contract as the warehouses running services and the generators costed money, and that payment was used to pay for these. If there are no further questions, I would like to conclude my submissions.
Yeah, please. Continue.
Thank you.
If it may so pleases the court, may I begin?
Please.
Greeting the honorable bench. My name is Harish Nadeem, and I am the senior counsel for the side appellant. I will be speaking for a total of 12 minutes, where my co-counsel Sheikh Ibrahim will be speaking for a total of 15 minutes. I will be covering issue 2. Yeah. Would the honorable bench like to hear a brief summary of facts? Or should the counsel proceed with the argument?
It's up to you.
All right. Honorable bench, starting with the brief summary of facts, Adventure PLC and FVX PLC are two companies. FVX emphasized on the state-of-art facilities to provide safeguard and shelter to high-yielding variety seeds which were possessed by Adventure. Furthermore, they emphasized that they will provide a shelter which will protect the seeds. In past 2020, there were protests taking place in FVX company due to the high carbon emissions. And furthermore, in 2020, when the contract was formed between them, a protest occurred, due to which the contract was claimed to be frustrated, which we argue that is not frustrated, and we are seeking for our damages and losses which were incurred. Should we proceed with our arguments? To begin with issue 1, issue 1 deals with whether the terms of the Service Agreement Act satisfy the reasonability test requirement under Section 11 of the Unfair Contract Terms Act 1977. Honorable Bench, I will be presenting my argument, which will be divided into two sections. Section 1 will deal about the inducement, and Section 2 will deal about the vagueness of the term. Honorable Bench, it is humbly submitted before you that the specific clause 4 of the Services Agreement, which is presented on Annexure A on the case facts page 3, it serves as a paragon of unreasonability, unfairness, and iniquity on the following grounds. Honorable Bench, the Unfair Contract Terms Acts establish the necessary requirement of a reasonability test to determine whether a specific clause or term within a contract is considered unfair. Would the Honorable Bench like to listen to the Section 11 of the Unfair Contract Term Act? All right. All right. Not sure. To move further, in simpler words, the act simply means that whether a contract is reasonable, it is determined whether the party knew or could have reasonably expected what the term could mean. Therefore, it's humbly pleaded before the Honorable Bench that Adventure PLC had no clue about the protest and whether it was beyond reasonable control. Furthermore, Adventure PLC was induced by FVX on the following grounds. Number one, we would like the Honorable Bench to refer to page 1, paragraph 3, line number 4 of the case facts. Page 1, para 3, line 4. where it is mentioned that FVX PLC emphasized the state-of-art security features of their warehouses, highlighting advanced surveillance systems and climate control environments. This provided Adventure PLC with the surety that their product would conform to the necessary requirement and their quality would be satisfied. Honorable Bench, relying on the case fact itself, due to the emphasis and the surety which was given by FX PLC to Adventure, made the decision of entering a contract with them, hence making their statement inducing in favor of FEX. Furthermore, the economic aspects which were given through FEX to Adventure became a highly significant reason of inducing Adventure into their contract. Furthermore, to begin with, the unreasonability of the clause 4 which was mentioned by the council, we would like to highlight the clause 4 on the case facts page 3 mentioned on annexure A. Clause 4 is a force majeure clause, but we are arguing that it is unreasonable on the following ground. Firstly, it is not specific in nature. The fact that the force majeure clause lacks specificity in defining the event it occurs. The clause only vaguely mentions that unforeseen circumstances, leaving room for interpretation and potential disputes. We would like the Honorable Bench to refer to page 2, paragraph 1 and line 5 of the memorial. Page 2, para 1, line 5 of the memorial, which tells us that the force majeure clause was made to safeguard both companies in order if there is a case of unweather conditions of the climate and of the weather. That was the only reason the force majeure clause was incorporated by both the parties. However, the terms which are mentioned in the contract tells us about acts of God, war, terrorism, but it doesn't mention anything about the climatic condition. Furthermore, if the FX company feel deemed necessary, they could have mentioned either third-party interventions or government interventions because it was foreseeable from the past actions. We are inferring from the past actions which took place back in 2020 that because of their high carbon emissions, there were protests. They knew that protests could take place and it was in their knowledge, which comes to the Schedule 2 Requirement 3, which tells us whether the company knows about what will happen or not. Coming to the fact that the time between those two periods, between 2020 and 2022, was the period of COVID-19. We could infer from the fact that during COVID-19, even though they were having carbon emissions, the protest is reasonably not going to take place because in the situation of COVID-19, firstly, civilians aren't getting out of their houses, and secondly, even if they feel that the carbon emissions are bad and need to protest, then they would not protest due to the guidelines of the COVID-19 and the SOPs set by the COVID-19. Furthermore, we would like to proceed with the fourth requirement, which is the practicability of the force majeure clause. Honorable Bench, we feel it deemed unreasonable that the practicability of force majeure clause will be applied on the grounds which were previously set by the council. Moving further, by satisfying the requirement, we would like to proceed to the case which is present on memorial, page 10 of our memorial, paragraph 7. The case of Michel Limited versus Finney Lock Seeds Limited. Under this case told us about how if both the parties are on unequal positions, then that term will specifically be deemed unreasonable and therefore unforceable. This is the first requirement set by the Schedule 2
Counsel, how can you specify that they were on unequal terms? How do you specify that?
Thank you for your question, my ladyship. This is specified with the fact. We would like to refer you to page of the case facts of page 1, paragraph 4, line 2. Page 1, paragraph 4, line 2. It tells us, and I quote, these facilities set FVX apart from the other companies, and Adventure quickly sent an offer letter to FVX. It tells us that the facilities which Adventure needed.
The paragraph you have just read mentions that an offer letter was sent by AgVenture to FVX. So there was a word, induced. How does that come into play here? Nobody induced anybody to sign anything, right?
Thank you for your question, your ladyship. The assurity which was given by FVX
The offer letter was sent by AgVenture to FVX. It was not the other way around.
Yes, your ladyship. Because it was a matter of mutual benefit. The Adventure was not claiming services for free. However, it was a mutual benefit which was not only benefiting Adventure but was in favor of FVX. So it was both way around. And coming to the question of unequal bargaining set out in Schedule 2, the only fact that there was no alternative present as per the case facts, they were the only one providing these services. And relying on the case facts, I will refer to paragraph 2 of the case facts, that the seeds which were possessed by Adventure were a high yielding variety seeds, and they needed a special climate condition which was only provided by FVX, and as per the case facts there was no alternative present. Therefore it led Adventure on a very unequal position of bargaining, because that was the only place through which Adventure seeds could be provided and could be kept safe, therefore satisfying the requirement of unequal bargaining, your ladyship. Does that satisfy the bench?
It does not.
All right. So we will move on the further factors which include the unequal bargaining. We will use the doctrine of undue influence here. The fifth.
Influence?
Yes.
You're taking a big risk here.
Your Lordship. We would like to communicate to the honorable bench that
you just said you confine yourself to the line of arguments. What is your exactly case? If you refer more and more, you will be in trouble.
Thank you, Lordship.
Confine your arguments. That's reasonableness, bona fide, at your part, and not the same thing has been done by the other side.
Thank you, Lordship. We would like to argue that the test which is set in the ACTA, Section 11, we would like to claim that the Section 4 force majeure clause is unreasonable. As claimed by the appellant that it was reasonable, it is unreasonable on the following grounds. It is unreasonable on the following grounds: that the event was foreseeable by FVX as the protests were taking place and their CSR policy have not seen.
What do you say? Was not your responsibility to be satisfied and go inspection everything before entering into contract?
In fact, you were the ones who made an offer.
So yeah, and doctrine of waiver would not apply on this part of argument.
Thank you, Lordship. Coming back to the particular article which we are claiming to be unreasonable, it said that FVX had to communicate Adventure in case if there is an event. They failed to comply with it, and there was no communication made by FVX to Adventure. I would like to refer to the similar clause 4.
Then how you have known to this problem?
Could you come back, please, Your Lordship?
So if they have not informed you, so how you have come to know about this, that you have been precluded to enter in the premises?
Thank you, Lordship. Coming to your question, it's written in the case fact that it was written in the case fact that Adventure claimed and filed the case 5 months prior. And coming to your question that how Adventure took the seats out, could you please refer to the case fact itself, which is on page 2. the seeds which are mentioned are high yielding variety seeds, and it's not mentioned on the case fact that they were the same seeds which were present in the warehouse, or they were the seeds which were already in possession of Egg Venture. It's not written in the case fact itself that whether they were the seeds within that warehouse or they were the seeds which were already possessed by Egg Venture.
You see, you have to confine to the contract. No?
Yes.
Clause 4 or 5 is the main,
Yes.
the core of,
Yes.
bone of contention between you. So, you show us from it that it was their fault.
Already, Lordship. Through clause 4, the inclusion.
Through your contract.
Yeah, through our contract.
Yeah.
The inclusion of clause 4 is unreasonable because the main purpose of this clause was to protect both the parties, but it was unilaterally favoring one party. Because of its unreasonability.
So, my question would be why you executed it.
Exactly. Why did you sign the contract with that clause?
Thank your ladyship and your lordship. The main purpose, the whole argument and contention here is arising on the force majeure clause. The purpose we signed this force majeure clause was mentioned clearly in the case fact that it was solely for the purpose of the weather condition. And since it's wide in terms, it says including but not limited to acts of God, war, terrorism. So the language, we would apply the rule of language here. That the act of...
Okay, we understand. What do you say about doctrine of frustration?
Doctrine of frustration. Yeah. We firmly believe that the frustration will not apply here and we would be entitled...
It's a mere sentence, or is there any reason or logic behind it?
Yeah, Lordship. There is a reasoning and logic behind the frustration and that issue 2 and 3 will be covered by my co-counsel if you may allow so. Thank you, Your Lordship.
Can assist us. Call
Your Lordship, my permission is seeking that since the time's up, would the bench allow the co-counsel?
we allow.
Absolutely.
Thank you.
Just on one point only.
Apologies.
Good afternoon, Your Lordship and my Ladyship. I am junior counsel for the side respondent in the case of FEX PLC versus Adventure PLC.
Your name, good name, please.
Sheikh Ibrahim.
Sheikh Ibrahim. Just assist us on single point. So, what about what is your defense of, or attack on the doctrine of frustration? We
Your
have already
Lordship.
heard your colleague.
Yes, Your Lordship, as we can see from the statement of relevant facts itself, how frustration had not occurred as the warehouse was sealed by the government authorities only temporarily, and as my learned counsel has already submitted before, that there was no frustration, and in case there was no frustration, the contract had to be completed. However, FEX
Tell
PLC...
us from the facts.
Yes, Your Lordship.
All facts must be in your hands. So tell us about it. So it was not, the doctrine of frustration cannot be invoked here. And for this reason, they are liable for the damages, losses, etc., etc.
Your Lordship, I would like you to refer to page number 2 of the statement of relevant facts, where it states, on paragraph 3, in response, authorities temporarily sealed the warehouse. And as per the case cited, Taylor versus Cadwell, if Your Lordship may refer, on page 12, paragraph 11 of the memorial, which states in order for a contract to be frustrated, it must be completely inaccessible, it must be impossible for the contract to continue. And as per the contract itself, if you may refer to the service agreement, annexure A, point number 5, which is, however, which states, point number 4, the affected party shall promptly notify the other party of such circumstances and take reasonable measures to presume performance as soon as possible. However, point number 4 of the warehouse service agreement, Your Lordship.
Warehouse service agreement.
Annexure A, page 3 of the...
It normally calls clause, not point.
Yes, clause 4, Your Lordship, which states,
and take reasonable measures to resume performance as soon as possible. However, as per the case facts itself, even after
What are the reasonable measures?
Your
Confine
Lordship,
yourself to the extent of the facts in your case.
Your Lordship,
Don't go on some other examples.
Your Lordship, as what can be seen from the case itself, that no reasonable measures were taken place during the time that the government authorities.
For example.
For example, during the time that the government authorities had sealed the warehouse, no notification was sent to Adventure PLC of the warehouse being sealed, Your Lordship. Furthermore, it was also never told that FVX, being such a big company, must have had several warehouses. In case of not only restraint to this one warehouse, they did not take any reasonable measure to transfer the goods from this warehouse to any other warehouse. And as per the statement of relevant facts itself, Adventure had to forcefully acquire another warehouse facility for their own for the storage of their seeds, which furthermore showcases the thing that there were other facilities also present in the above case. However, FVX did not try to go towards those or provide a reasonable outcome for the situation itself. After the government authorities and I would like to emphasize on the word temporarily sealed the warehouse, after the temporarily seal had ended, even then FVX did not notify Adventure. They did not make any reasonable measures to ensure that the seeds were safe, the climate control was met, the carbon footprint was emitted. During 2020 and 2022, FVX did not try to reduce the carbon footprint itself. They only supposedly incorporated corporate social responsibility, which was not incorporated in any sort, which can be seen from the statement of relevant facts. The protest had only intensified over the 2 years, and that is the reason the government authorities had sealed down the warehouse. But once again, the warehouse was only sealed temporarily, which showcases the fact that the contract was only.
Okay, what do you say? This clause 5, beyond reasonable control.
Your Lordship, once again, when the warehouse was sealed by the competent authorities, FVX did not even try to.
You are repeating the same thing.
My apologies, Your Lordship. FVX did not contact the certain authorities as well. What they could have done in order to mitigate the laws, in order to fulfill their responsibility, was to have contacted the certain authorities as well, which would have furthermore mitigated the laws issued, and it could have provided with the fact that the warehouse could have been unsealed at a sooner date. They could have been more careful about their corporate social responsibility. They could have assured the government and the relevant authorities as well.
Corporate social responsibility is something else. You have to seek relief from your contract and breach of contract.
Yes, Your Lord.
By FVS. So, how do you say about beyond reasonable control? Was it in their control, the circumstances, whatever happened here?
Yes, Your Lordship, there were
were not in their control.
Your Lordship, there were reasonable measures that FVX could have taken place in order to mitigate the loss for themselves and Adventure as well. They could have moved the seeds to another warehouse facility before the protest, during the protest, and during the time before the warehouse was sealed. They could have also furthermore notified Adventure so that they could have taken reasonable steps in order to mitigate their loss. They did not do any of this, which furthermore showcases their
Counsel, I want
intentions.
to ask you, what kind of losses did you actually incur?
Your Ladyship, we had paid an upfront payment of $30,000 and no consideration was given in exchange for those $30,000.
No, but what were the real actual damages that were caused to you?
The real actual damages
apart from the warehouse being inaccessible.
Yes, Your Ladyship.
Were your seeds stored in that warehouse?
My Ladyship, even though the seeds were not stored in the warehouse, it can also be seen that the seeds needed certain attentions and immediate attention.
So you mean to say it was perishable good?
Yes, Your Lordship, it was a perishable good, and due to the fact that the warehouse was inaccessible, FVX could not be reached, they did not notify us. We had to take immediate measures in order to acquire another warehouse, which was another cost incurred.
Lost to understand, could not notify us. Once the premises is handed over to you, was it their responsibility to notify you, or it's some sort of responsibility on your shoulder as well?
Your Lordship, as per the statement of facts itself, the only reasonable thing that Adventure thought to do of was to acquire another warehouse in order to protect their seeds at that time. Even for that,
Counsel, I want to ask you one thing. Please answer this very clearly. Were your seeds, the high yielding seeds, were they stored in the warehouse?
no, Your Ladyship, they were not
Did
stored in
you
the
have anything at stake in that warehouse? The only problem that you faced as a venture was inaccessibility. Other than that, was there any loss or damage caused to you?
Yes, Your Ladyship. In order to acquire the new warehouse, we had to pay the new warehouse and the warehouse that was acquired after FVX a payment as well. That was our loss as well because we had already paid it to FVX and then going again and paying it. And during that time, seeds were damaged as well because they were a perishable item.
What was the quantum of damage caused to you?
My Ladyship, can you please repeat your question?
Quantum of damage. How much losses did you face due to the actual loss? How the valuation of the seeds?
No such factors have been mentioned, and the case facts stay silent on that.
Can I safely say there were no seeds lost?
No, Your Ladyship, there were seed loss because
It hasn't been mentioned anywhere in the statement of facts.
My Ladyship, my apologies. That can be clearly seen because of the fact, and it can be inferred from the case facts of how the seeds were perishable.
We can't infer facts. We have to know for sure.
Yes, Your Ladyship.
So you see that you don't have idea. You means your case in case you have brought before us. So you don't have idea of damages and you're asking from the court. So what would be the consequences of it?
Your Lordship, as per what we can see, is that the damages would be the $30,000 that had initially been paid.
So
And
unless you show us, demonstrate through the quantum of damages that how you lost it.
Yes,
That straight away you have given to them one of the aspects. What about your perishable? What are your commitments? What you ought to supply to the other side you have not mentioned. So these are some sort of quantum. If you don't have, आप इस पे तैयारी करें, and then
For how much time the warehouses remain sealed?
Even that is not mentioned, and the case facts stay silent on that fact, my Lord.
Once the premises was given to you on rental basis for
Yes,
your
Lord.
storage, okay? Due to certain reason of whatever it is, premises was sealed.
Yes, Your
And
Lordship.
after how much days it was removed? Number
Your
one.
Lordship.
My next question is, if the seal was removed, then you were at liberty to store your seals there again. Why didn't do this?
Your Lordship, that is because FVX PLC had not been in contact, and even after certain tries to contact FVX, they were out of contact.
Your contract is silent about it. Don't go on this site. Your contract is silent about it.
You must be aware with these circumstances because the premises was in your control on rental basis, okay?
Yes, Your Lordship.
It was sealed due to certain reasons after 10 days or 15 days or 20 days if the seal was removed. Then you were at liberty to store your goods there.
But during
Why
that,
avoided the same?
Your Lordship, because during that period of time, we had already acquired the new storage facilities because of the fact that the
During that period of seal,
Yes,
how
Your
much
Lordship.
your consignment you
Was
had
wasted.
to-
Was wasted.
either vested or stored in some other warehouse.
Yes. Alternatives.
At higher price.
This is called the quantum.
Otherwise,
We have to
how
have
you
this.
will be able to get refund or you will first get the question.
How you justify
refund?
that you actually have?
Show us your losses.
my
So you have to
apologies.
keep 2 containers. You have taken another alternative place, and for
All is
this
for
you
you.
have borne further losses of rent and transportation and whatever be.
Yes, my Lordship, as per the statement of facts are silent on that, I will not be able to provide the Honorable
Okay.
Court with the facts of the quantum of the and the amount of the
Okay.
damages,
So-
but I will be able to provide what damages were
So,
incurred.
so your case is that so they have violated, they have breached the contract.
Yes, Your Lordship.
They have not provided the place. And that was, although it has been sealed by the government, but they have not notified you prior in time.
Yes, Your Lordship, exactly.
And then you escape damages, and then you say, it's whatever advance we have given to them, they ought to return to us in
Yes,
shape
Your
of
Lordship.
damages.
The advance that has to be returned to us comes under the
So
law.
advance comes under the definition of recovery. What you have given to him, you want to recover, because you have given to them with certain ideas or with certain terms and conditions as a part performance of your contract that have not been done by them. So come on this point and you want to damages on this term.
Yes, Your Lordship. The damages that we will be seeking will be the damages for the warehouse that we had to acquire, and the warehouse that we had to acquire at a higher charge than FVX itself, and we had to acquire it very suddenly because of the fact that
Sorry, this cannot be your argument at higher charge. You have entered into contract, you have voluntarily signed it. This is not your, is unacceptable for us. So confine on your contract. I don't know, your colleague and you both are going out of it. Confine on your clauses that have been breached by the FVX.
Your Lordship, if you may look at Clause 5 of the Warehouse Service Agreement,
Yes.
which states, Party A agrees to indemnify and hold Party B from any claims, losses, or damages arising out of the warehouse gross negligence or willful misconduct. What we will be trying to prove will be the gross negligence of FVX PLC
Yes.
itself. The gross negligence can be seen from the fact that FVX PLC had not notified Egventure, they had not taken reasonable measures for the corporate social responsibility to be incorporated. And furthermore, even after the warehouse was temporarily sealed, they did not deem it necessary, and because of its willful misconduct and its malified intention, to get into contact with Egventure PLC itself for the storage of the seeds. Furthermore, it can also be stated.
Then again, the point is come on the doctrine of frustration. What do you say?
Once, as per I have already stated, Your Lordship, we believe that the frustrating event has not taken place, and because of which.
So you mean they have managed this whole episode of government sealing or like that?
Yes, Your Lordship, they have already
How
managed
could
that.
it be? So a reasonable inference can be drawn and acceptable to the opinion can be formed by the court. It's totally unacceptable that a party can influence the government to block all the area for the only reason that you would not be allowed to enter and keep storage, because on the other hand they are also losing the rent, the forthcoming what they have committed for other business or like that for expansion of business. You understand what I'm saying?
Yes, Your Lordship.
So this is a prudent man cannot will not accept.
Counsel, in the meanwhile, while all this was happening, was there at any point any communication from your end to them? You were aware that the warehouse was inaccessible and sealed. You were aware, right?
Yes, Your Lordship.
Was there any communication from your part with them to find out if there was any alternative remedy available, or you just the best possible choice or decision that you took immediately was to find some other place?
Your Lordship, due to the special conditions of the seeds, and they needed special requirements, what we ought to do was, in order to first secure our seeds, and after securing the seeds, bring legal actions against them because of the.
I understand they had a 15% market share.
Yes, Your
That
Lordship.
means that there must have been other warehouses and storage facilities.
Yes,
Why
Your
did you not negotiate to have your seeds stored in another facility,
Your
which was owned
Ladyship,
by them?
As per the statement of relevant facts, which state.
It states that they had a 15% share.
Yes, Your Ladyship. However, the statement of relevant fact also stays silent on the fact whether they had other alternative warehouses or they were.
So did you
only
try to find out, actually? My question is, was there ever a discussion if they had any alternative facility in that area or nearby?
that the statement of relevant facts stays silent on that part.
So in other words, you did not actually sit down or talk to them to find out if there was any other arrangement they could offer a solution to the problem. You just immediately went to get another warehouse facility.
Yes, exactly.
At whatever rates that you negotiated with that party, right?
So have you informed them? So if they have not notified, have you informed by notice or some communication?
No such communication.
So the contract apply reciprocally. They have not notified you, so also you have not notified. So we have to strike it out in our decision.
That is upon the discretion of the.
Thank you.
One question I have.
Yes, Your Lordship.
Again, regarding clause 5 of the agreement, you just referred regarding the gross negligence and willful misconduct.
Yes, Your Lordship.
That is your claim for damages.
Yes, Your
These
Lordship.
are the main reasons.
Yes, Your Lordship.
My question is, once the government release the ban upon the premises after 10 days or 15 days or whatever it is.
Yes, Your
It
Lordship.
means the government was satisfied that there is no major issue.
Yes, Your
Okay?
Lordship.
It is not the proof that there is no gross negligence or willful misconduct on part of the appellant.
Your
Otherwise,
Lordship.
the government was not required to release the embargo after 10 days or 15 days.
Your Lordship, the misconduct, the willful misconduct, and the gross negligence that we are talking about are.
No, just to explain willful misconduct and negligence.
Yes, Your Lordship.
How you will define your case in light of gross negligence and misconduct when the government removed the ban after certain days?
Your Lordship, the misconduct and the gross negligence was not due to the CSR policy, but was because of the fact that they did not notify Adventure PLC, they did not try to notify, or they did not want to notify because of their willful
My
misconduct
learned
itself.
friend asked you to notify, both the parties were bound. Okay?
Yes, Your Lordship.
One committed default. Your right were going to be deprived. You were supposed to inform.
Were you an affected party in this case?
Yes, Your Lordship.
You were. Have you read the
Prosecuting
Annexure
upon
A?
your right.
Yes, Your
The
Ladyship.
clause 4 mentions very clearly in the last line, the affected party shall promptly notify the other party of such circumstances and take reasonable measure to resume performance. So it was also partly your responsibility to notify and to inform
And
that
it's,
you are being affected.
it was your case. The onus of burden lies upon you.
When you've taken a storage place or a warehouse, you've rented it out, right?
Yes, Your Ladyship.
Some of the responsibility will be
Your
with
right
you.
for more than 5 months.
Yes, Your Lordship. Once again, Your Lordship, the case facts remain silent on the fact whether any communication was there between both of the parties.
So you cannot take it up now. No? Once there's a waiver between both parties, so contract is reciprocal. So it's binding upon both parties. If he has not done, so for your case, you have also not done it. So this. I think
The line of defense is not
this is
so
not
strong.
your line.
Exactly.
You cannot take this. You have to confine on the principle of equity.
Yes, Your Lordship.
What you want to do from the other side, you have to do for yourself first.
Furthermore, Your Lordship, coming back to your questions, in the circumstances where the contract was indeed frustrated.
Okay,
and
we have heard you. So any other of your counsel wants to argue?
no
on
further
this
submissions, I would like to move with the prayers.
Point? Okay.
In light of the issues raised, argument advanced, and authorities cited, it is humbly submitted that this Honorable Court may be pleased to adjudge and declare that FEX PLC has incorporated unfair terms into the contract. All such terms should not be obligated on Adventure. The contract was not frustrated, and consequently, in accordance with the force majeure clause being unfair, FEX should not be liable to the damages caused for the damages caused to Adventure. Finally, Section 1, Subsection 2 of the Law Reform Frustrated Contract Act 1943 is applicable, and accordingly, FVX is obligated to reimburse any expenses incurred as a result.
So, but there is a provision in this proviso. Read the proviso of section 1, 2. Subsection 2. Do you have copy?
Yes, I have a copy. Section 2, Subsection 1 states, all sums paid or payable to
This
any...
is the next proviso.
I do not have the act with me, Your Lordship.
So we have a tradition. So if the defense, he has argued, if you want to say in rebuttal, I don't know what's yeah, okay. Thank you very much. Come, please.
With the permission of the Honorable Bench,
Yes,
may I
yes.
begin my submission?
Now tell us, first of all, so it's your premises?
The
FVX?
respondent party states that the term
Ma'am, I'm framing some questions for you, for your convenience. So, it's your premises. You have offered.
no,
You are the owner of premises.
yes.
Yes, and you offered on a rental basis.
Can you please rephrase your questions?
So, FVX is the owner of the land. store, warehouse,
Yes.
or not? You are the
Yes.
owner.
Yes.
You offered him.
No.
Then they
They were the
offered
one.
you.
Yeah.
Okay, you accepted it. And
Yes.
there is a contract.
Yes.
So when there is some problem and it was sealed, so why you have not notified? What do you say?
As I mentioned in my arguments as well, that the protest was very intense and FPX did not had the chance to respond to notify them. Apart from this, according to the agreement, clause number 5 clearly states in the last line that, however, party A shall not be liable for any losses or damages resulting from factors beyond its reasonable
Yeah,
control.
this is a contract, but as a principle of equity.
Yeah.
So a substantial amount would have to come in your pocket as well.
Yes.
So you are also an interested party. So what were the circumstances that you have not noticed?
Thank you for the question, Your Lordship. The government grant that they were the initial payment of 50% that they had to pay, they only paid only $30,000. They hadn't fulfilled the full amount, and they said that there would be a government grant that they're relying on. Hence, there were no measures taken about the government grant.
So that these were the conditions they have already told you. There is no misrepresentation on their part.
Yes.
But what is your opinion that you have not notified them? Tell us from.
That even if we had or even if we had not, according to clause number 5 in the last line, as I stated.
I understand according to clause number 5,
Yes.
they are liable.
Yes.
But what do you say in your case? Why you have not notified or claim that still the amount is?
That the protest was very intense, and the protest was very intense, and they escalated very quickly. And apart from that
Okay.
protest,
Now,
are known.
my second question would be, so after the protest has been over, the premises have been desealed, the warehouse was open. So have you sent them notice that now my place has been available for you, come and utilize the services or whatever the place or warehouse?
We hadn't notified or contacted them, as they after 5 months they just terminated the contract and sued us for the money, as
They-
is stated in the case facts as well.
Yeah, read it. Termination, how and when. That's very important. That show your bona fide or mala fide.
That 5 months later, in July 2022, Adventure made the decisive choice to take legal action against FEX, seeking recovery of the amount incurred.
That's the legal action.
Yeah.
After 5 months.
Yes.
Were you sleeping in between the duration?
No,
Yeah.
they didn't even notify us that they were going to see.
They did not. He
Yes.
has concisely told us clearly. What do you say about it? Because it was your place. You had obviously some idea in your mind. If I'll take 30,000 USD from here, then after some time I'll take 50,000. Then I will invest some other place. What was your plan in your mind? So you have shown your good intention that my place now, the government demonstration or protest or whatever be the nuisance has been over. My premises are available. I have taken the 30,000 advance from you, so I'm the bona fide person. So I'm showing you my good intention for the performance of this contract.
Thank you for the question, Your Lordship. But as is also already mentioned in the case fact, they already found alternative storages from other companies.
So you mean to say that you have never contacted them after once the government has locked the area, you have not contacted them?
No, neither they have.
So this means the result, you can understand the inference of this statement?
We have not even notified them for one of
Take
these
help
reasons.
from your friends.
We have not.
I think so. So if anyone wants to support her, so please let them. अच्छी हो जी.
May I have your permission to please go to my bench?
Yeah, please.
Your Lordship, the question that you asked, I would like to say in the counter of it, that protests are a part of public knowledge, and with a company who has such a big market share of 30% should have known about it. They also should have done their legal background research as well. Even during the formation of the contract, no such occurrence had been mentioned by the agriculture.
Counsel, were you not under any obligation to actually sit down and talk to them and to discuss the issue?
We were not any obligation.
You were not under any obligation.
According to the contract, we were not. As I mentioned in clause number 5, it clearly states that party A shall not be liable for it, for any losses or damages occurred by the agriculture.
You mean to say that the protests were not affecting you in any way? It was entirely their headache.
They were affecting us because it was our warehouses who were being closed down. But on the other side of the hand, adventure has a very large market share of 30%, and protests are a part of public
My
knowledge.
question will always be again that any party who is being affected by anything has to notify the other party. It is very clearly stated in clause 5.
But according to the Schedule 2 of Part A, the Adventure LTD was in the bargaining power.
My question is, after desealing of the premises,
Sorry?
after desealing of the premises by the government, okay,
Yeah.
were you willing to continue this contract or not? Because you were supposed to receive 6 month rent on monthly basis and 50% of the security deposit amount. Okay?
Yes.
After desealing, did you approach the other side to pay my monthly rent? And
Yes.
now you can store your goods and
Yes.
pay me the balance 50,000.
Yes, sir.
Is it on record?
It's mentioned in the memorial. They they could have asked us to seek the alternatives, but it was
Nothing is in writing.
No, it's not about if they could have asked you, it was whether you made an offer to them or not. You say that
Yes.
you were not obligated to make any
After desealing,
offer.
if you didn't approach them, it means you were not willing to continue your contract.
Listen, as I told you, notice means once you talk, enter into negotiation or communication or conversation, whatever means you have, either on phone, conversation, or communication through mail, postage, whatever. So this is also includes as notice in judicial language.
Yes.
So they have given you 30,000 USD, and the remaining amount is still payable by them. So my learned friend has asked you, so I also about notice. Notice means subsequent to the event. Which event?
Protest.
Substitute the event.
Protest. After subsequent to the event, was there any contract between you both parties, or
No.
you both set it on
As-
your offices and says goodbye?
The contract between any type of contact between the two parties is not mentioned in the case facts.
No. What would be your line of argument? You are before us with a case.
Yes.
So as appeal, that the order is bad.
Yes.
It's bad. You want to set aside it. That's precisely your prayer.
Can you please ask me that question again?
Yeah. So what action has you taken, or what contract you have entered with the adventure after the desealing or after the protest?
We have not contacted them. Either they have, because I'm standing on my argument that protests are a part of public knowledge.
Then go to the clause 5 of the contract. The first line, party A, you agree. Are you with us?
Yes.
Clause 5. Party A,
Party agrees to indemnity and holds harmless
to
party.
indemnify,
Yeah.
hold.
Yes.
So you have given indemnity
Yes.
under the doctrine of indemnity.
Yes.
So you indemnity and hold harmless party B.
Yes.
Indemnified with harmlessing from any claims, losses or damages. So you have given indemnity, but you have not contacted him.
Because even if we had, or even if we hadn't, we shall not be liable for any losses or damages against them. And as I said, agriculture has a very large market share of 30%. Public knowledge of this, of a company who is facing protest and they're in contract, we should have known this thing. Protest is known as a public knowledge. There's no one, and honestly, I would like to say, Your Lordship, your Ladyship, that there was no mention in the case facts that uh, that we had any kind of an government, that we had any kind of an initiative or any kind of a warning from the government
Okay,
that the protest would happen.
how do you rebut his arguments? The lastly, Consul Sheikh Ibrahim has submitted before us
That
about the warehouse was temporarily sealed.
Yes.
Temporarily sealed.
Yes.
Then
Once the inspection was over, the warehouse would have gone back to their normal state and the contract should have been continued. But the respondent chose to terminate the contract without notifying us. Moreover, the council has also mentioned that in clause number 4, the term unforeseeable event is open to interpretation when it's clearly long, well, as the clause has self-mentioned, but is not limited to. We have, as the appellants, we have relied on the term not limited to. That's why we are saying that the protests were an unforeseen event, and it happened 2 years ago, and the contract was made 2 years after. So in those 2 years, no protests occurred.
And would you able to assess us? This was the first time protest has been occurred in this whole vicinity or area or locality.
The first protest
So
occurred.
You come with this point as well.
Yeah, the
So
first
show us your bona fide.
The first protest occurred in 2020, and when the second protest occurred, it was 2 years later when we were in contract with the Adventure. During the formation of contract, no such thing was mentioned by the Adventure LTD. Even though such big company of a 30% market share with bargaining power.
How much amount you have incurred the expenses?
It's not mentioned in the.
For the warehouse.
It has not mentioned.
But
in
have
the
you
case
done
files.
it or not?
Sorry.
Have you done it or not?
Yes, we have given them their services.
You have incurred some expenses over.
Yes, we have incurred some.
Yeah, that's
That's
part
why
of
we
your
refuse.
fact.
That's why
That's
as
a
a
part
parent-
of your fact.
Yes, that's why we
On that
refuse.
account, on that account, you have received 30,000 USD.
Yes.
Yes.
The remaining amount is yet to be given. That's why we are refusing that we won't pay for any losses. That's it.
With the permission of the Honorable, may I begin with the rebuttals? Yes. Honorable Bench, the first thing which was mentioned by the appellant was that there was no performance done by their side and the seeds were not kept in their warehouse. So how come the appellant could tell us and demand in front of the Honorable Bench that they have incurred expenses when they themselves specifically claimed that no performance was done from their side? Secondly, coming back to the
On what understanding you have made it, or you have advanced the payment?
could you come back please again?
On what understanding you have made payments in advance to them? What was in your mind, in your company's mind?
That was purely on the reliance and the surety given by them that they would provide us services. On that surety and reliance, we granted them the
They
payment.
have provided the services. They says that this is beyond our control. This has happened. We are here. Our warehouse is here. Come and enjoy the facilities and pay us to money. What's the problem then?
Thank you, Lordship. But the parent themselves mentioned that no performance has been done by their end and the seeds were not kept.
You didn't understand the question. Once you paid $30,000, okay? He provided all facilities in the premises. And due to certain reason, there was some seal or deseal of the premises. But your money was utilized by them for providing all these utilities in the premises. Then how you can say, now you refund me all this amount?
What was in your mind when you were advancing them money? What was your in mind?
Thank you, Lordship. To answer that question, the way there was no alternative present in the market, the way there was the monopoly.
So you have to, that's, you're voluntary. The contract is always voluntary. So you have no case of duress. Have you framed your case on duress basis, coercion basis?
Inducement also, that was one of your
Inducement
favorite
Yes, Your
words.
Lordship. It was purely on the basis of inducement that we were,
How?
How do you
because
induce
No,
someone
no,
to
no,
sign
no,
a
no.
contract? Please explain.
Contract can be
When the offer has been sent from you, AgVenture was the company that sent the offer.
The problem with you is you have executed the contract. You have paid voluntary payments, 30,000 USD. Now you cannot take, it was under duress. It was under intimidation. So you have no line because it's unacceptable. Once you are signing the contract, you are advancing the payments. How could you say? So if your line of argument is that we have no other solution, that was the only feasible place. So it's your choice. They have not forced you to come and put your pressure to sign the contracts. That's not a duress. So you have advanced the payments. So you have to show that you have performed the contract. So you have advanced the payment on the understanding that this will be happened. So that's why you are giving him advance. Just tell us this.
all right. To answer your question, Honorable Lordship, the concept of undue influence mentions the presumed influence. Under presumed influence, the fact which is contained in that is trust and confidence. And the trust and confidence was given to us by FEX through emphasizing on their state-of-art facilities and by providing us a specific climate condition which was required for us. So through that presumed influence, through the trust and confidence given by them, made us give them an advance.
Were you the one who made the offer to take the warehouses or storage places first, or were they who came to you to offer the places?
Your Ladyship, since they were the only, it was a mutual benefit. It was a
They were
mutually,
the only.
Yes.
You're saying that.
yeah. There was no alternate. There was no
So
alternative.
now, when you say that they were the only, where were you storing your seeds after the protest? You find an alternative to store for the warehousing, for the storage of your seeds. Is that correct? That means they were not the only option available.
Your Ladyship, referring to your question, since the case facts themselves tell us that there were significantly not other options. As
They were just 15% of the market share, right?
Your Ladyship, to answer that question, they are different of niches. See, they are different of niches. Their industry and our industries are two different industries. So it could be inferred from that a 15% in a specific industry could be considered really high dominance, whereas a 30%.
But you will agree that there were other alternatives available, and eventually you relied on one of the other alternatives available. Is that correct?
Your Ladyship,
When you were not using their storage facility, you found an alternative. Is that correct?
That's partially correct, Your Ladyship.
Yes.
That's
So
partially.
that means that they were not the only option available and dominating the market. Is that correct?
No, you listen.
Yes,
Then
Lord.
it's a law, it's a jurisprudence, you can say, the self-contradictory please reduce the weights. Okay. So one time you say that's the only place, so I have no choice. For this reason, I made 30,000 USD advance. And for this, now I'm here to recover these losses. That's, and on the other hand, no one but you approached them, you offered them, and then you made payments. So these two self-contradictory, number one. Number two, your conduct. Your conduct is that subsequently you kept storage on some other place. So your arguments contradictory is reducing the weight. Now, tell us,
Yeah, thank you, Lordship. To answer your question,
that's my point. Tell us, after the desealing of the area, have you approached them to utilize the place because your money was in their pocket?
all right, much obliged, Your Lordship. To answer that question, we would like to bring through two things into attention. Firstly, about the alternative facilities. As per the case fact, it's not mentioned whether those alternative facilities provided the same state-of-art facilities which were promised by FAX. And secondly, coming to the Annexure A Clause 4, we would like to bring it to your attention that the affected party shall promptly notify the other party of such circumstances. Here, we would like to bring to your attention that the affected party regarding the circumstances was FEX and not Adventure. Therefore, FEX...
How is the Adventure not an affected party? Please explain, I don't understand.
Your Ladyship, Adventure is an affected party, but within the context of this particular clause, it mentions the affected party shall promptly notify the other party of such circumstances. So here, the circumstances took place with FX, and therefore, they were the party who were bound to tell Adventure about the protests which were taking place. And secondly, to move further with the clause 5, which is of indemnification, it tells us about gross negligence and willful misconduct. So FEX was indeed at gross negligence when they did not communicate it to Adventure, leading towards seeking of damages.
So your precise argument is, under the compulsion circumstances, you have taken an alternative. Otherwise, the warehouse was excellent, state of art. So first argument is this.
Yes, Your Lordship.
Now, tell us, after the desailing of the area, have you contacted or requested them that since I have already given you the money, so please let me allow to keep storage?
Prior to going to court.
Yeah.
Thank you, Your Lordship, for the question. We, firstly, the case facts remain silent on it, and secondly, we thought it practical to approach the High Court first, and indeed the High Court made the favor in case of Adventure.
Try to understand the question.
Don't skip the gap.
Apologies, Your Lordship.
Question is, prior to sealing
Yes, Your Lordship.
and after the de-sealing, you didn't store anything in the premises. You are not restricted by them. You are not restricted by them. Now the question arises for the said sealing period. For that sealing period, so how much consignment were on board for which you have to arrange alternate arrangement, or the same were destroyed? Number one. Number two, once you didn't store anything prior to sealing, and despite there no restriction, you avoided to store your goods after the de-sealing, then you are responsible for the same. Why you are asking for refund from them after 5 months?
Thank you,
And
Lordship.
why you kept left for 5 months?
Thank you, Lordship.
Well, just give a simply reply so we can conclude this. So, after vanishing the protests, everything's now. Give us reply. You can consult your team. Two questions, simple questions.
Sure.
Have they prevented you to enter into the warehouse to utilize the facilities under the contract which they are bound to do? Number one. Number two, so have you ever approached them after the protest has been over, everything has been normalized, and before the final institution of the case, have you approached them, please give us the place?
All right.
Give these two replies after consultation.
Thank you, Your Lordship.
Yes.
If the Lordship may allow. Yes. All right. The Lordship, firstly, relying on the case facts, relying on the case facts, there's nowhere mentioned that there was the de-sealing of the warehouse. And secondly, there was no de-sealing of the warehouse. Therefore, we inferring and relying on that particular clause, we get to know that Adventure was not in a state to take out the seeds from the warehouse since there was no de-sealing. And coming towards your second question was regarding whether Adventure was bound to communicate to FEX.
No, I'm not asking bound to communicate. I'm just asking you, has Adventure approached them to let us allow? Or not?
The case facts remain silent on this matter.
Okay, I want to ask one last question only now. Which one of the two parties actually terminated this agreement?
which of the party actually terminated
The
this
agreement,
contract?
whether it was FEX or Adventure.
It was FEX.
They did.
Show us
They-
from
are
the
you
facts.
sure?
Show us from the facts.
Could you please come back again?
From the facts.
From the
Chief.
facts, can you just prove that which
Show us.
party terminated the agreement?
We normally do this bullies in court, and then when the judge asks, the result might be changed then.
All right, Your Lordship, to answer.
So now the last question is from you both. Show us who has terminated the contract.
Honorable Ladyship, to answer a question, relying on the last paragraph, there was we would like you to excuse from the previous statement
Last
through the,
paragraph of
of
the fact.
page 2 of the case facts. Adventure made the decisive choice to take legal action against FPX, and above that, it is mentioned that due to the temporary sealing of the warehouse for inspection, Adventure was rendered inaccessible to the warehouse. And with the warehouse facility temporarily available, Adventure was forced to secure alternative storage facilities. So, Adventure secured other facilities with their facilities being
So
unavailable.
for my own clarity now, just yes or no mein
All
jawab
right.
do. Now I want to say, or ask rather, is did you terminate the contract?
Because there was a breach of contract. Your
Did
Lordship.
you terminate the contract?
Yes, Your Lordship. We would like to
You
excuse.
terminated the contract, it has not been mentioned anywhere. And the little knowledge of law that I have tells me that if a contract is actually not formally terminated by either one of the two parties, both of them had the opportunity to, then the contract is still in place.
Your Lordship, if you may allow to answer that.
Yes, please.
The respondent counsel is firmly believing on the ground that there is a breach of contract by FPX, and through that breach of contract, we are seeking for damages.
Breach is a different thing. Termination is different thing. So just tell the reply of
The clause 3 mentions each party may terminate
who
the
has
agreement
terminated the agreement.
with written notice if
According
other
to
party
you.
breaches any material terms and condition. Which of the two parties actually
Terminated. Just
terminated the
first-
agreement?
first
Just
tell
one
us.
answer.
Honorable Lordship and Ladyship, this particular case facts,
Cancel the record.
This
Show the facts. Don't reply abruptly.
this case.
Consult the record and
Yes,
tell us
actually
who
you
is-
should
All right.
consult.
Thank you so much.
The contract was actually not terminated and they were supposed to pay rent.
Filing of
Acha. They did come.
If the honorable bench may allow the counsel to answer that question. Honorable bench, it is inferred from the case facts, since the case facts remain silent, it is inferred that it was Adventure PLC who terminated the contract since there was non-performance by their end.
So when you terminated before filing the case or after filing the case?
Honorable bench, we will not be able to seize the court in this matter since the case facts remain silent.
So is it written in your fact sheet that the contract was terminated by Adventures?
Your Lordship, we just said that we inferred from the case facts and the case facts remain silent. That's why we are only inferring from it. We are not relying on the case fact itself.
So then you are lucky they have not made a counterclaim. You would have to pay the rent.
To answer that question, if you may allow.
Yes.
If the contract was not terminated by you or by either party, it means contract remain in force till your filing of the case. It means you are liable to pay the rent for that 5 months period. And why you are asking refund of the deposit amount, you are liable to pay the rent for the 5 months period.
But
Because
there is no counter
contract
claim.
repudiated by
There
any
is no counter claim from their side. No? So you are safe to that extent.
All right. Much obliged, Your Lordship. Just a final wrap-up argument, if the Lordship may allow.
Yes, yes.
As mentioned previously, we are inferring from that it was Adventure who terminated the contract and relying on the indemnify clause out of their gross negligence, they are bound to pay us any damages, claims, and losses. Which indemnify clause
is conditional, my brother.
Listen.
The indemnify clause.
should I read it?
Yeah.
Your Lordship. Thank you. Party A agrees to indemnify and hold harmless Party B from any claims, losses, or damages arising out of the warehouse's gross negligence
Okay. Gross negligence
or willful misconduct.
or willful misconduct. You didn't explain in your entire argument, and you both the counsel, any event of gross negligence or willful misconduct on part of the appellant.
Should I answer that if the honorable, honorable bench, it was communicated by the council on the fact that since the protests were taking place, it was their gross negligence that they weren't able to communicate with us.
Now, recall my previous question.
Uh,
Once the government desealed the premises after a few days, it means there was no serious issue. Otherwise, there was no possibility to deseal the premises. Once the premises was desealed after a few days, it means contract remained continue and you were able to store your goods therein. Why you kept silent for 5 months without giving them notice, repudiation of the contract, nor you stored the goods? It means you willingly didn't choose to store these goods there. And even otherwise, if there was a counter claim on their part, then you are liable for the payment of 5 months rent.
Much obliged, Your Lordship. Should I answer that question?
Yes.
Yeah. Your Lordship, the case facts didn't tell us, and the case facts is not telling us that the warehouse was desealed. There's nowhere written in the case facts itself that they're desealing of the warehouse itself. And we are not inferring that, we are relying on the case fact itself.
Listen,
Yes, Your Lordship.
if you have done a good effort that warehouse is still silent about.
Yes, Your
So your movement towards another warehouse and your silence to take back the premises for which you have paid the money, what's demonstrate? What we may form opinion about it.
Thank you for your question. Your Lordship, as per the case fact and relying on the case fact, it's mentioned that the HYV seats were taken to other alternatives. It's nowhere mentioned in the case that those were the same seats presented in their warehouses. Since Adventure is a...
No. You have taken the premises or warehouse for rental purposes to utilize to keep storage your goods yieldings. It's a perishable. If it damaged, they are liable for. That's why your course curriculum has inserted this field. Otherwise, they can say it's twice. It's like this. That's perishable item has been kept in it is for meaningful purpose. No, you don't go this. So you say I want to place grade A in their storage room. I have acquired another place for grade D seats. This is not the case before us. Your case is, so your conduct is you have paid money. You are here for recovery of damages and losses, whatever you have sustained according to you. And for alternative arrangement, you have approached another and utilized another place. And subsequently, you instituted a case. Okay. In the meanwhile, have you approached them for utilization of place? There is no point on your point. You have ever notified them? You have no point. So what would be your line of arguments on this?
Much obliged, Your Lordship. To answer your question, firstly, about the alternative. The state-of-art facility which we provided with them, we had no other option but to have an alternative, but it is inferred from the case fact that that alternative was not up to the standards of the warehouse facilities which was being provided by the FVX.
Then we will say go and utilize that place. Why you are avoiding it? There is no protest.
To answer your question, there is nowhere written in the case fact that the sealed warehouse is desealed. We are still inferring it from the fact that the warehouse is still sealed.
Because you try to understand the sealing is interconnected, interlinked with the protest. It has written in the facts that this sealing is for a particular purpose. That purpose was the law and order situation or protest, and that has been over now. So now, if you are come before a court for asking something from the court, you have to demonstrate your good intention.
Yeah. Much obliged, Your Lordship. The case facts are still silent on the fact that whether the protests are over or not. We could still infer from the case facts, see, the protests are not always physical. There are also virtual campaigns or protests which take place.
Okay.
Thank you, Your
Thank you
Lordship.
very much. Thank you very much.
The court is now adjourned. It is requested for all of you to remain seated while the judges deliberate.
Sorry.
Please remain seated as the judges take a brief moment to deliberate and score the team's performances. Following this, our esteemed judges will provide feedback to our participants. Thank you. I request the guests to please take their seats as the judges give out their deliberations to the participating teams. Thank you.
Okay, so I will speak first, and then of course the senior lawyers will come. But one thing I would like to say that it was very, very engaging and interesting. One of the most interesting moot competitions I've ever been to. The teams were very well prepared. Whoever the mooting coach is gets a gold medal for sure. And I think both the teams were extremely well mentored. I would give credit to that as well. For the appellant team, I think Hamna, you spoke very well. You speak with a lot of confidence. I really loved the way you presented your case. And I think you were very well assisted by Shamir. Shamir, is that the correct name? Okay, Shamir, you did a great job. And the researcher was Rehma. Laiba, okay, Laiba. Laiba, I think you were also on your toes. It was very impressive. It is a good team, and I admire the way you courageously stood. And I duly apologize for the innumerable questions. This I'm saying to both the teams. Initially, I was not asking questions. But then, as usual, the judge gets a WhatsApp and they start questioning. So you can blame Mr. John Hussain. This was highly apolitical. It does not mean anything. Mr. Mukati, with all due respect, I received a WhatsApp and then I was compelled to ask questions. So now you know who is responsible for the questions. Okay, on the other side, we have Harris. Harris, I have seen you argue cases before as well. I was here for the last moot court as well. And even then, my opinion of you is that someday you are going to be one of the best defense attorney in a criminal case. And for Ibrahim, you did well, but you were under a lot of stress. Initially, there was a ponytail. Eventually, it was not there. So I can imagine the stress that you faced because there was extraordinary grilling. Apart from that, I think your researcher is Asad. Asad, by the end of this mooting competition, was getting panic attacks, palpitations, migraines. I could see all that, but I'm sorry. And it was only for your own good and for your own training. I don't know what the total marks will be, who will get what, who is the winning, who has the winning case. I have really no clue. But I still say that both teams were extraordinary, and whichever side wins, I think margin jo hoga, it will be very, very minimal, as in half a mark or 1 mark maybe. But both of the teams really did well, and it's highly impressive that such talent is here, and mashallah, mashallah, doing so well. So a big hand. And I would like to request. Okay.
I would like to fully acknowledge the comments of my dear colleague Ms. Asma. Both the teams, being the students of first LHB, did their best. And our question was, prior to the start of this session, I had suggested that we will raise some question to check the IQ of the participants and their presence mind, because our question must be out of their scope of study. So we will be able to judge that how much they can cope the situation if arises suddenly. And normally it's happened in court. And therefore we made some efforts to puzzle you. But the purpose behind this, all these things was to give you knowledge and to give you courage to face the practical courts and the question queries of the judges. And you must be present mind and ready to attend each and every question. And I appreciate all of you. And some sorts of lagging at this stage must be. So this is not a complaint, but try to make sure that you are within the limitation, within the boundaries of your case. If you will go beyond the boundaries of the case, you will lose. Always remain within the boundaries of the facts of the case. So then you will be able to argue most confidently. And try to understand the question of the courts. Question of the courts are just to bring out, unearth the things which you have concealed. So be careful to reply the question of the courts. Question of the courts are not according to the facts, but to unearth the facts. Facts mentioned therein, we don't know whether the facts are or not. But whatever concealed therein, judges want to try to unearth the same. And therefore you must be alert to listen the question. Don't be aggressive to reply. Be the good listener of the question, then you will be able to reply properly, otherwise you will lose your case. So this is my suggestion to all of you, but I appreciate all of you. All are best, not good, not better, best. At this stage, it is best.
Thank you very much. So I start with Salim Bhai's the words to understanding the question. So it's a quite to understanding the question is a half answer. So try to understand. This is very good thing which has been conveyed to you. So it's a very impressive performance by both the teams. So it's a really impressive thing that the case law is a very good factual case law has been framed and included in the curriculum. So it gives you a lot of exercise mentally and understanding. It will enhance your academic galleries for the aspiring lawyers. Hamna, she has done a great, and she has a good vocal powers, arguments. It's the first year, obviously. You act like a lawyer. We don't feel here that you are a student here, the way you are responding us. So, very good arguments, but you have to still a little bit work with how the facts would connect with the case laws. So the case laws is the main thing to develop your research. Any case law, take any case law, research it, you will observe few lines, few principles, few settlements for your own knowledge. So Shamir is very good. She is also argued very well, confidently, with very good vocal power. And this Laiba, she has done a good job because we try to bulldoze you here and there and all like that. So people also ask me when I go to Sindh Public Commission for test interviews of prosecutor or appointment of lawyers, government, they always run away and cry. Some girls won't cry. So, but nevertheless, so we have given you time, and there was a good response, which is inspiring for us. So you all three have done a good performance. Now coming to this site, is a very good hires, very good arguments. Although your case is doctrine or hitting by doctrine of frustration or like that, but you have well managed. But one thing is, if someone try to confuse you, so we say like that. Again, I'm going to another way. So if you cannot convince the court, at least confuse. So so you tried, but the main thing is, so again, I tried, understand, don't abrupt response, sudden response. Observe it, and then respond it. What is my understanding of question is very important for you. And Ibrahim is a good vocal power, but is a good. He's tried very well prepared, and replied in a positive way. But so still need more potentiality, more stamina. So researcher is very serious. It's very serious. So that's a very important thing. So for any profession, so you have to be a serious. Agar, if you want to study so many notes and like you are in this university, so many things, but you lose the concentration, you will miss the train. So the concentration is your seriousness. If you take the thing seriously for 5 minutes, 10 minutes, rather than to study for 2 hours, but non-serious attitude is nothing. But this researcher, he's tried. We have given the case because one time the Haris has surrendered himself when we say it, who is terminated, and now. So you have replied very good 2-3 points. So I really appreciate that. So, in this sense, that's compulsions for the alternative. That's very smartly you played. So, nevertheless, I found all you very good and wish for your best future success. All of you. Thank you.
Thank you, esteemed judges. And finally, the moment that we have all been waiting for, the announcement of the winners. To make this anticipated announcement, I request the honorable judges to please come forward to present the awards, and Ms. Rafia Jaffer, Dr. Mukati, and Mr. Imtiaz Qazi, the Vice President of Administration, to join them. Thank you.
Okay, so let's start with the announcement of awards. I think this final was very worthy of being a final. The teams were very well matched, and there's just a 1-point difference in who wins and who doesn't. So I would like to thank the judges. I think your questioning, your grilling, I think that was very necessary for the training of our students, and I think that made the match very, very exciting. So I will first start with the announcement of the award of Best Memorial. The award of Best Memorial goes to Team 007, Zunair, Irfan, and Ikra. Can we please have you on stage? This team was a semi-finalist, and their memorial has been graded to be the best one in all the teams that have participated. The next is the award for Best Researcher. Best Researcher goes to Laiba Arshad. The next award we have is for Best Oralist, and a student from an A-level school has won this award, Amna Imran from Lyceum College. Let us come to the announcement of winners now. By a margin of just 1 point, the winners are the respondents. Congratulations to Sheikh Ibrahim, Haris Nadeem, and Asad Raza. Congratulations to the winners, but can the runners-up, Laiba Arshad, Hamna Shehryar, and Shamir Ansar Ali be on stage? I would now like to request Dr. Mukati to present a token of thanks to each of our judges for today.